All right, it is time to do an in-depth performance review of Senator Todd Lakey. And I mentioned before this is an interesting case because of his sponsorship and direct involvement regarding. I mean, we'll watch the videos, but regarding abortion. So when you look at a lot of these ratings, they don't. There's no score on Christianity or maintaining moral values. You can see here education index, which freedom index, and then spending index, which is down low. But yeah, it these think tanks, so to speak, tend to focus more on the materialistic aspect or more the ideological, like libertarian, small government, low taxes sort of point of view. Uh, I guess you have to go to other agencies regarding the abortion stance. Here in CPAC, his score was about 80%. Now in their bill rating system, remember it's just a plus or minus. They're all weighted equally. Previously, his average is 69%, and I guess last or 2022 he was at 64%. And then let's see what else. There was another one, the Institute for Legislative Analysis, and he received 55% philosophically Republican, which was on the spectrum. Now, how they exactly measured it and where that line is, I don't know. I guess you can read it specifically. I guess it's better than being Republican and being like these 13 Republican and being labeled as philosophically Democrat. So, but he's on the borderline. And once again, I'm not sure how they measure it. I think it could be related to the financial aspect, which is often tends to be it. And then of course the IACI support. IACI, which is basically the Idaho Chamber of Commerce, they merged with the Association for Industry. There's their PAC arm, super PAC arm, Idaho Prosperity Fund. They support him. Now that tends to either be, well, you can read up on IACI. Enough has been said about them. I don't need to go into depth on that. All right, so let's go. I'm going to close all these windows out so I don't have too many. Start getting confused. We'll leave. I should have left one of those up. Hold on. This one I got to leave up here. These ones I'm going to close. All right. So, Stop Idaho Rhinos. They have a list of bills that this is more easily written out, and we're going to be able to see exactly where the bills are. Now, on here, he doesn't have abortion on here. Yeah, I mean, I guess it's just assumed if you're Republican, you're anti-abortion. But what we'll be seeing, after I review some of these bills, or how he has spoken within the Senate hearings or within committees, yeah, you'll be able to hear his own words. So afterwards, I'll go through abortion and some like bonus ones if you're still sticking around. But I'm assuming that if Stop Idaho Rhinos, refers to these, I'll go through the red ones, which and then I'll go back to like the trans surgeries, because he was actually, Senator Lakey, like he should get bonus points, right? So if you're like the chairman and you're having to like be the tip of the spear for some of these, including like the anti-abortion bill, if you're on the spear tip, like you should get bonus points. That's the for taking the heat on that. But anyway, we'll get back to that so you can see exactly his involvement with that. So let's start with the school choice. I'm going to pull up the video. That is, here it is. So bear with me, I got to pull all of this live. Different files. 226.
after un
Okay.
Thank you, Mr. President. Senators, I'll try to be brief as well. I certainly respect all the opinions that have been expressed on the floor today. Myself, personally, I've gone back and forth on this bill over the last month. I'm a supporter of school choice, and that is a benefit to our kids. We have public schools. I support their specialization, open enrollment policies. We've done great things with charter schools. We've worked to protect the autonomy of our homeschoolers. I've had the opportunity to judge their public speaking contests a handful of times, and they have some very sharp kids in that program. But we talk about choice. We have choice. This is about funding. And, as I've listened over the last month plus to both sides, I support the concept and appreciate the concept of getting some funds back to individuals that aren't requiring an expenditure of funds or burdening the system if their children are not using the public schools. But after all of that weighing and evaluating, I find I can't support this legislation. Our Constitution's been referenced already. It's to provide a public free common schools. It doesn't talk about private schools. It doesn't talk about home schools. I'm not saying that this legislation is unconstitutional. But we don't get to pick and choose what the obligations are under our Constitution. If we don't like it, we strive to change it like we did earlier. Or we strive to improve the public school systems and the system that we have, and there's absolutely more to do there. But I don't think there's enough respect for the Constitution and our obligation that's laid out in the Constitution in this bill. And I do agree it lacks accountability. In regard to the expenditure of public funds, we always strive to make sure that those funds are spent wisely and that the funds are used effectively. I'm not going to go into portions of the bill, but for schools, we want accountability for results. We don't want poor teachers to be overly compensated. We don't want them to be protected simply because of time and tenure, but that compensation should be based on performance and ability. So, Senators, I do feel like this lacks accountability. There was some concern that I also agree with regarding the price tag and what JFAC may be facing in the future. But I'll say one thing that was particularly telling to me was some recent communication we received from Homeschool Idaho and their board that represents over 3,000 Idaho. And they recognize the importance of our constitutional obligation and the importance of accountability regarding expenditure of taxpayer funds. And they basically thanked us for our previous support, said they're doing just fine. They don't need the money, they don't want the money, and they don't need an additional program. So with those things, Senators, I will be voting against the bill.
Is there further debate?
Okay, so there's that one. A little bit of background. I believe it was like a $9,000 or so credit to families that home educate. I'm not sure if it was like a tax credit or something like that. And then some of the homeschools, what he was referring to, were actually against it, or associations, because they felt that the moment they started receiving money from the government will start, requiring paperwork and start interfering in their abilities to, manage their family. So there's that one. Okay, I'm skipping the amnesty thing. It's just it's just virtue signaling. Dear President Biden, please don't please do this. Yeah, forget it. I'm not going to waste time on that. All right. Okay, we'll go back to the spending because that was a big issue regarding the launch grant program. Medicaid expansion. I think this was also why I don't think he spoke on that, actually. He just gave his vote, and likely on that day, I believe it was. We'll open that up. I believe that was the March 30th when they voted on that. Yeah, it just he spoke a lot because that was also the day that his abortion bill came out. So, probably didn't feel the need to dominate the floor that day. All right, so we did those. Now we're going to go back and the trans thing is its own deal. We'll get back to that. So let's go to the launch grant program. He actually voted no on that. And you have to remember that Senator Lakey, let me see if I can pull this up, is receiving, quite a bit of money from various agencies. Let me see if I can show you what I'm referring to. In terms of being reminded about the amount of money he's received. Hold on, let me get that up. All right, so this was these were the amount. This was the amount of money he received from the primaries in 2022, I believe, or 2020. Yeah, 2022 primaries, and you can see here they're primarily from, Idaho companies. $1,000 is the maximum contribution limit. And so the typical narrative is that, they're called, they say rhinos, is that whoever receives, this kind of money gets corrupted by them and is, in their pockets, so to speak. Now the launch program specifically, he voted against it. So that sort of like counters that argument, because if you're supposedly in the pocket of the launch program or of the IACI and crony capitalists, you would think that he would vote for it. So anyway, let's go to him talking about this launch program, H24. Launch program, here it is, 2/12/29. So
the Senate will be in order. The first.
I'm playing this at, I think, 1.5 speed. 2/12/29, so we can get through this.
The reasons that have been discussed on the floor, local business, because we saw that to show this is what Idaho is asking for, and
so I believe the cost was like $130 million. And remember, companies, the corporate tax, I think, is like $1 billion.
I'm thankful to the senator from 33 for bringing that to us today. Thank you.
Thank you. Is there further debate?
Mr. President.
Senator Lakey.
To debate the bill.
You have the floor.
Thank you, Mr. President. Senators.
All right, let me see. Maybe it's going 2x speed. I don't know what the playback speed is. I'm going to make it a little bit slower. Oh, 1.4. So it was 1.5. All right. I'm going to go back to 1.5.
Maybe I'll just start with a general encouraging note, Senators. There are some senators that like to debate more than others, and I don't want to crush the optimism of those that like to debate. Sometimes I come to the floor with my mind made up, sometimes I don't. In this case, I'm debating against, so my mind's made up, but it's not made up in every case. So don't feel like your optimism shouldn't exist when you stand up and debate a bill. Senators, I think the motives of the sponsors in this case are pure. I absolutely do. I think we have good Idaho employers that support this, good Idaho legislators that support it. We need to support career technical education. We have a need, that's demonstrated. We need trained employees. But from my perspective, we need to do more in K through 12 to support this issue. We have great kids in high school that have been described already. Some of those kids come out of there with an associate's degree, some with a good solid base of college credit. I know they have some career-focused programs in K through 12 right now that relate to this CTE. And those kind of things need to be supported and from my perspective, expanded. We do have a problem with our go-on rate. But from my perspective, if we focus on K through 12, maybe we can get them before they go on, or provide a strong platform so it costs less for them to go on, and they have that momentum and that enthusiasm to go on. High school and post-secondary does need to coordinate with our private sector. They need to meet the demand that's out there. I've toured CWI and other of our community college campuses. They have great CTE programs, and they do coordinate with our employers. I think, again, there is a desire to provide a solution. I just don't agree with the solution. Senators, this solution is managed and overseen and implemented by a body that doesn't have legislative accountability. They don't promulgate rules, which in turn are reviewed and approved by the legislature. We have $102 million in existing budget capacity, $80 million from the in-demand career fund, and $22 from the opportunity scholarship portion. That's $200 million without the appropriate legislative accountability in my mind. There's also a minimum in this bill of $8,500. It's not merit-based. You simply have to get into the school, and those requirements really are minimal. There's no real skin in the game or personal accountability for these students that get this. And we all heard a few years ago the program that was proposed at the federal level, free college for everyone. I remember how I didn't feel overly positive about that. And this one perhaps is a little bit worse in that it's free college for some and not for all. So, Senators, I just don't think this is an appropriate use of our taxpayer funds. I prefer to focus on our K-12. Thank you, Mr. President.
So what's interesting is he mentioned an unelected group that would decide, what are how to distribute the funds. And so, that's, I believe it was like, it's like government or governor appointed. So, this is an example where he's going against that crony capitalist narrative and directly calling out, we're not in control of the governor's, appointed board. So, all right, let's keep going. All right, here's the trans items. I think the rest are going to be kind of a hodgepodge of things. I didn't go through every single bill. I just did what I could find. And I think let's say abortion is going to be the bigger issue. There's abortion, there's the trans items, but I think abortion really is probably the key issue. And specifically, when you type in Senator Todd Lakey, he's getting a lot of hate nationally because the Roe versus Wade overturn, and then Idaho had like an automatic kicker that banned it, and then now everything is now it's like going to it is at the Supreme Court regarding this position, and so there is a national level of interest, and because Senator Todd Lakey was the sponsor, and he is spearheading like an update to the abortion bill. He's been quoted, and he is the lightning rod on this, and so I'm not sure that deserves to me bonus points, because who wants to do that? All right, so and get the calls and all the emails. I mean, all right, let's just go through this. And here, this is supposedly the big controversial quote that you'll see quoted everywhere. I could not find the video of him actually in the hearing, but this is what the pro-abortionists are like saying, losing their mind over. So here's a quote from Senator Lakey on this.
Decision was based solely on a question of some type of health, then you're talking about taking the life of the unborn child. So that weighs more heavily than simply health.
Go ahead.
Thank you, Mr. Chairman. And just a follow-up. So just I guess a yes or no. The health of the woman's irrelevant, yes or no?
I would say it weighs less, yes, than the life of the child.
So that quote, this section right here, weighs less, yes, than the life of the child, regarding the health of the mother, is what just blew everybody's mind. So here's, I guess, another discussion part of this.
I noticed in the definition section that there is a definition for medical emergency, but we don't use that in this case. We use kind of some convoluted language, and I'm just wondering, Why not use this definition of medical emergency in this section?
Now, I will point out, I believe Senator Melissa Winthrow, she is the Senate Minority Leader and is also backed by IACI. So, you know, in this case, they are absolute opponents. So when they say, oh, everyone's in the pockets of IACI, when it comes to this issue of abortion, you have them, you know, against each other. So here we go.
Of code versus this treatment of how we're going to deal with if the woman is going to die, basically. See what I'm saying?
Senator Lakey.
Mr. Chairman and Senator Wintrow, that essentially was, you know, our decision. Our decision in this case, in the initial law, was to focus on the life of the mother, that being the exception that was provided versus more of a health exception. And that was part of what the Supreme Court looked at in the Planned Parenthood case. That's historically been Idaho's precedent, is since its founding, to focus on the life of the mother as an exception. So that was our decision, was to focus on the life versus more of a health type exception.
Senator Wintrow.
Thank you, Mr. Chair and Senator Lakey. I appreciate that clarification. So really, it's about a more kind of a firm stance of we're going to take care of death versus overall health or long-term health implications if there's a complication, it sounds like.
Senator Lakey.
Mr. Chairman and Senator Wintrow, as I said, yeah, the focus is on the life of the mother.
Thank you.
Okay, so let's continue. Now we're going to go to the actual bill on the floor and the discussion. And then we'll go to like some other items here. Because this was, yeah, this is the 7-hour hearing. 7 hours. Boy. And
Senate will
I'm
be
going
in-
to just jump around and see if I can locate this.
Legislation. In this and she present the further reading of House Bill 337 be dispensed with. The journal show has been read the third time at length and properly placed before the Senate for final consideration.
Without objection, it is so ordered. Senator Lakey, you recognize to begin the debate on 337.
Thank you, Mr. President. Senators, as you know, for the past several years, we've been working on occupational licensing reform. It's been a bipartisan effort. This bill kind of comes in that vein.
So because this is a 7-hour hearing, I'm just going to jump through it all the times that he talked through it so you can listen to it. We'll get to the abortion thing eventually on there, but this one's a different bill.
Past several years, there's been a lot of back and forth and different opinion between legislators, contractors, the industry, and labor organizations on issues surrounding the electrical code. And this bill deals with that, including the apprentice to journeyman ratios. Some legislators, again on both sides, I think, of the aisle, have been trying to achieve, in an occupational licensing reform context, less regulation and a broader scope of practice. And this bill does some of those things. This year, a rule was also rejected regarding the ratios, and then there was strong encouragement for all the stakeholders to get around the table and work things out and come together on those issues. And like I said, this bill is a result of that effort. I do want to thank all those that were involved in putting this legislation together. There was, as usual, give and take on everybody's part, but there's a healthy dose of more opportunity and reduced regulation in this legislation for those that are practicing their occupation as an electrician. So, Senators, this adopts the 2023 Electrical Code in statute. So now we have more control as a legislature over the applicable code, the applicable electrical code. It does allow some specific modifications to that code by rule, which, as you know, we're also actively engaged in, particularly in this context in the two germane committees on both sides of the rotunda. This, typically, the general electrician license levels are apprentice, journeyman, and master. And historically, they're essentially treated the same as to commercial and residential construction. This enables a new category called a residential electrician, which essentially allows them to function with less experience than your typical journeyman, but only in the residential context. So I'm not an electrician, but I understand that the residential context is less hazardous, so to speak, than the voltages you're dealing with in a commercial and an industrial project. So it provides also a definition of that residential context, that being 1 to 2 family dwellings, and then it adds townhomes and multifamily structures up to 3 stories. And that residential electrician still is required to have 2 years of coursework and 4,000 hours of experience. So it's not just somebody that picks up the profession and hasn't got any experience. It also expands the scope of work allowed for a journeyman to include planning, layout, and design, which historically has been within the scope of the master electrician. So it expands the scope of that journeyman, but it is within their scope and experience. It acknowledges that the apprentice statute, or excuse me, the apprentice status is a student status. In other words, they're going to learn on the job. And that requires progress in that field. So you don't get to be an eternal student. I remember in college, sometimes you see those 30-year-olds that are still living in the dorms and haven't figured out what they're going to do with life. I guess this is kind of in that vein. You have 8 years to obtain your journeyman in the residential context, 6 years to obtain your journeyman in other contexts. And it doesn't limit the amount of time you can take the exams. You can take them as many times as you would like within that time frame. It does maintain the continuing education requirements for journeyman and master, but it removes the requirement for the apprentices since that's what they're doing. They're going to work to learn every day. It does increase the penalties for some violations. It expands the journeyman-apprentice ratio. So in the residential context, it's 1 journeyman to 4 apprentices currently. It expands that to 1 to 6. And in the commercial and industrial, it stayed the same at 1 to 2, but a 4th-year apprentice with 6,000 hours of experience does not count against your ratio. And then lastly, it again preempts local government from adopting more stringent requirements regarding the ratios. With that, Senators, Mr. President, debate is open.
Is there further debate?
Mr. President,
Senator
I would like to declare 39H, just to be on the safe side. My son is an electrician.
Declaration will be noted in the journal. Is there further debate? Senator Lakey, you're recognized to stand and close the debate.
Thank you, Mr. President. Senators, I ask for your aye vote in this collaborative effort. Debate is closed.
Debate being closed, the question before the Senate is, shall House Bill number 337 pass? The Secretary will call the roll.
All right. I mean, yeah, I mean, that's probably why he's getting some money from the various associations, if you follow that. Good for you. All right, we'll keep going here. Find the next one. Here we go. Okay.
For final consideration.
Hearing no objection, it is so ordered. Senator Lakey, you're recognized to open the debate on the bill.
Thank you, Mr. President. Senators, this deals with a criminal offense that's described as abortion trafficking. That covers an adult who, with the intent to conceal an abortion from the parent or guardian, procures an abortion or an abortion-inducing drug to be used in the abortion for a pregnant minor by recruiting, harboring, or transporting that pregnant minor within the state. So that's the confines of the criminal conduct here. It focuses on an adult who acts to conceal this and then takes actions in furtherance of that while concealing it from the parent or guardian. It does provide an affirmative defense if the parent or guardian consented. It provides that the Attorney General can prosecute, in this case, if the local prosecuting attorney refuses to prosecute without regard to the facts or circumstances. There's a sentence of 2 to 5 years. It also amends the civil cause of action section and provides that there's no compensatory or punitive damages if those damages were paid in a previous case. It provides that there's no cause of action for a person who committed rape, sexual assault, or incest, or other criminal conduct that impregnated the pregnant woman. And then it also lists circumstances that are not defenses in the civil cause of action and addresses attorney's fees. Gives the court discretion to not award attorney's fees and costs where the action may be frivolous, without foundation, or in bad faith, and then provides the opportunity, the discretion to award attorney's fees to the prevailing party in an action defending the constitutionality. And remember, Senators, that there were some amendments to this bill. We removed the inappropriate references to enforcement regarding 18622 and the application of certain insurance provisions, and it trued up the statute of limitations. With that, Mr. President, debate is open.
The debate being open, is there further debate?
Thank you, Mr. President, to debate against the bill.
Senator Winthrop, you have the floor to debate the bill.
Thank you, Mr. President.
Okay, let's go to the next one. Okay, here it is. Oh, let's see, he's talking again.
Talking about that, I'm just talking about what is prohibited under the law. And from next, your legal, I'd say do that. I know this is a little facetious.
Mr. President, I think I have the question to the senator's question from earlier.
Does the senator wish to debate the bill for the second time?
I do briefly answer that question.
Well, the question has been asked and answered, and we're moved on.
Happy to debate a second time.
Does anyone wish to debate the bill for the first time? Senator Winthrop, you're recognized to debate the bill for the second time.
Thank you, Mr. President and senators. I think the senator.
Okay, I don't know where it went. I thought I found it. There it is. Okay.
Senators, do appreciate the debate. We clearly recognize we have differences of opinion on the abortion issue, but I do thank senators from 19, 1, 6, 28, 7, and 29 for their debate. Obviously, abortion is an important issue. It's one that generates strong feelings, and we have set the state policy in Idaho. And thankfully, after Dobbs, we have the authority to do that. Trafficking is a crime that we define in a particular context. That's our job as legislators, is to define what is criminal conduct. And I think it's more appropriate because the definition of trafficking in this context regarding abortion is different than trafficking in other contexts. I think it avoids confusion by putting it here instead of putting it in the general human trafficking section, because again, the definitions are different. The intent, particularly here, the nefarious intent, is that an adult is doing something with the intent and with the furtherance of action to conceal an activity with a minor from that minor's parent or guardian. That's the first thing that has to happen, that they're taking these actions to recruit, to transport outside of the knowledge of the parent of that minor. And it does apply to acts within the state. Again, we have the authority and the obligation and the opportunity to establish criminal laws in Idaho. And to take those acts in Idaho, that's what we're saying is a crime. It doesn't happen when they cross the state line. It happens when they take the furtherance and when they act in this capacity to facilitate and procure an abortion and then get that minor to travel within the state to pursue that abortion. Senators, this also narrows the scope of the cause of action. As was mentioned, it doesn't change some existing code. If there's potential work on existing code, then that's legislation for another day. With that, Senators, this is important legislation that does help protect our kids. It does help prevent and protect against abortion, especially those that occur without the consent of the parent in another state. I'd ask for your aye vote. Debate is closed.
Okay.
Senator Lakey.
Mr. President, I ask unanimous consent that further reading of House Bill 374 be dispensed with. The journal show it's been read the third time at length and properly placed before the Senate for final consideration.
Without objection, it is so ordered. Senator Lakey, you are recognized to begin the debate.
Thank you, Mr. President. Senators, this bill is literally the result of session-long discussions. This topic came up really at the beginning of the session, if not before. And there's been a lot of discussion, back and forth, debate, and this is where that discussion evolved. Senators, as you know, Idaho's law prohibiting abortion became effective after the U.S. Supreme Court, in the Dobbs decision, returned the authority to regulate abortion to the states. Our current law was passed a few years before that in hopes that the Supreme Court would properly return this authority to the states. Senators, I just want to lay out a little bit of the current state of legal proceedings, because that was part of the discussion and part of what generated this legislation. So the federal government challenged our current law in the context of emergency rooms. And on August 24th, 2022, Judge Windmill issued his decision granting a preliminary injunction while the case proceeded through litigation. And that preliminary injunction and that challenge was the application of the law only in the context of the emergency room, which is governed under federal law in specific circumstances. It's governed under the Emergency Medical Treatment and Labor Act, or EMTALA. You may have heard that before. His decision was largely based, Judge Windmill's decision was largely based on his interpretation of Idaho's abortion law. After Judge Windmill's decision, approximately 4 months later, on January 5th, 2023, the Idaho Supreme Court issued its decision upholding Idaho's abortion law over Planned Parenthood's challenge. And that case is really fascinating. It's long, if you have an opportunity to read it, but it's extremely thorough. Judge Brody's decision was very thorough and well-written. And the court found that Idaho's law was in conformance with historic Idaho law. That was part of the constitutional analysis, and that the law was in fact constitutional under the Idaho Constitution. In its review, the court went back and looked at the abortion laws in Idaho since our early territorial days. And back in the first territorial legislative sessions, the Idaho legislature passed a prohibition on abortion. And that prohibition prohibited abortion unless it was necessary to save the life of the mother. And that law also provided a penalty of 2 to 5 years for those that violated that law. And that same prohibition and consequence was really consistent through the state of Idaho until Roe. And our current law reflects that. So it was a felony with a 2 to 5 year penalty. This law essentially is the same thing. It focuses on an exception related to the life of the mother and provides that penalty. In that case, our Supreme Court interpreted and applied Idaho's abortion law. Their interpretation of Idaho law is binding on Judge Windmill and his federal decision as far as the application of Idaho law, and removes a lot of his interpretive basis for his decision. Senators, that federal case regarding the emergency room is still pending, and there's a request for reconsideration that's been made by the state of Idaho, but to my knowledge, that request has not yet been determined. All of that said, Senators, the discussions to this point have included a review of that Idaho Supreme Court case, and also we've listened to some of the concerns that have been raised by folks, including medical providers. That brings me now to the bill itself. So in this bill, Senators, we are including additional language that, from my perspective, was reflective of our original intent, but it also codifies the application and the finding of that intent in the Supreme Court decision. It makes amendments to the exceptions to the definition of abortion, and those exceptions are the following: removal of a dead unborn child, removal of an ectopic or moral pregnancy, and treatment of a woman who is no longer pregnant. And for reference, Idaho Code provides a definition of pregnancy, which includes when a woman is pregnant as long as that fetus is developing. So a non-viable pregnancy where that fetus is no longer developing is treatment of a woman who's no longer pregnant. That was recognized by the Supreme Court. And even early in this session, Senators, we were hearing concerns that ectopic pregnancies are not covered, that these non-viable situations are not covered and they're prohibited. That was not the case, nor was that our intent. The Supreme Court noted in their interpretation in their decision that the current law does not include these situations. So we are codifying these exceptions for clarity and, frankly, for transparency. So folks can't make that argument. They aren't confused. The average citizen is more likely to look at the code versus read an Idaho Supreme Court decision. The bill also removes the trigger language, which made it effective when the Dobbs decision came out, since it's now effective, so that's no longer necessary. It also changes the approach to some of the exceptions that we have listed in code. One of those exceptions, the first one, is the good faith medical judgment of the physician that the abortion is necessary to prevent the death of the mother. So that's your life exception. And Senators, it's a subjective exception. It's the subjective good faith medical judgment of that doctor. It doesn't provide limitations on that scope, on that timing. As the Supreme Court described it, it's a wide path for that doctor to exercise that discretion. And then the second exception is for rape and incest. So those exceptions, the language has not changed, but our approach to them changes under this legislation. Currently, the law provides that these exceptions are dealt with as an affirmative defense. Judge Windmill spent a lot of time complaining about an affirmative defense approach in his decision. But the Idaho Supreme Court clarified that this approach was lawful and constitutional, so it was appropriate to utilize that method. However, we've also heard concerns from physicians regarding an affirmative defense versus a straight exception, so to speak. And for those of you that may not understand, affirmative defense is raised later after the charges are filed, where an exception applies before the charges are filed. So as I said, this leaves the description the same, but changes the approach. And Senators, I think you know I'm a former prosecutor. I don't see a large practical difference between the two. An affirmative defense, if a prosecutor knows there's a viable affirmative defense, they're not going to file the charges. If the prosecutor knows there's a viable exception, they're not going to file the charges. But that said, we are trying to address the concerns that were raised. So it changes that from affirmative defense to just a standard exception. The legislation also qualifies that rape and incest, that exception applies in the first trimester. So that has to be raised. It also specifies that a copy of the police report or Child Protective Services report that's required to be provided to substantiate that claim of rape or incest remains a confidential part of the medical record for that individual. It also clarifies there were questions raised whether the pregnant woman that raised that exception could get a copy of that police report or that child protection report. And in our public records law, there's an exception for a request that may interfere with a pending investigation. And normally the response to that would be not to say you don't get anything, it would be to provide a redacted document. The copy of the report, but it may have a lot of things redacted. But this clarifies the ability of that woman that raises that exception to obtain a copy of that report in a redacted format, so it can be provided. Senators, this clarifies our intent. It's responsive to some of the concerns that has been raised, and it also maintains our strong commitment in the state of Idaho to protect the life of the mother and the life of the unborn child. With that, I'd ask for your aye vote, and debate is open.
Mr. President, to debate the bill.
Senator Foreman, you have the.
Okay. And there's our favorite. You might start noticing a pattern here. That was the abortion one, obviously. So this was a long day for them. Okay, here we go. Here's another one. I mean, yeah, here we go.
The effort to try to make sure that we are secure. I certainly have concerns with China and Russia. It really can't be a controlling interest. So I think.
Okay, so this one has to deal with, I guess, foreign companies or China, specific government entities buying land. So, farmland. We heard that a lot in the news about China buying up all the farmland. By the way, I'm not Chinese, all right? I was born in the USA. My parents are from Korea, South Korea, okay? Not North. All right, here we go.
I think this is a narrow sliver, and what we're saying about this land is we don't want foreign governments having a controlling interest over this land.
So for the debate,
Mr. President, debate bill.
Lakey.
Thank you, Mr. President. Senators, I kind of struggled with this. I really appreciate the purpose, the effort to try to make sure that we are secure. I certainly have concerns with China and Russia. But I think my comments line up with some previous comments that the senator from 6 made before. We really are not talking about just the buyer, we're talking about the seller. And we are stepping on the property rights of the seller. If Australia wants to come in and buy my 20 acres of farm ground, or Ireland, or Great Britain, I don't have a problem with that. I practice land use law, and I always struggle a little bit when people come to a land use hearing and protest some property owner's application to do something with their property, particularly in regards to agricultural ground. One of the favorite things they like to say is, we need to preserve our farm ground. And frankly, there's no such thing as our ground, our farm ground. It's not a collective we that owns this property. Unless you live in a socialist or communist country, then it belongs to everybody. But we're not talking about our anything. We're talking about property that belongs to an individual. So with that, I will be voting against the bill.
Okay. I mean, even, yeah, I mean, that bill's a interesting one. Actually, I didn't read the bill language, so I think they were specifically referring to government agencies. I wouldn't necessarily say everyone who voted against, the prohibition of foreign governments buying farmland automatically means they're in the pockets of the Chinese government. I mean, if you're worried, like, there's a matter of degrees. It's like, I think the Asian population, now if you're in like Vancouver, you have like 30% ethnic Chinese, Vancouver, British Columbia. So that maybe might be a bigger concern. But I mean, come on, like, I'm like the only, how many Asian people do you see around Idaho or Southeast Asian? I mean, I posted in Cuno Must Know, and people thought I was a fake account because, like, how many Asians actually post? So this might be it for Senator Lakey speaking. Okay, we got through that 7-hour hearing. If I missed anything, I'm sorry. The transgender things. Senator Lakey is the chairman for the Judiciary and Rules Committee, and all bills that get voted on have to pass through one of these committees. So he has a lot of power in that aspect. And let me see if I can pull up here the actual hearing, or sorry, the committee hearing regarding the trans surgeries, in which he gives his opinion on that. Let's see if I can find this. Here it is. This was a 2.5 hour hearing, and you can actually go to these hearings and publicly testify. So, yeah, this was 2 hours and 24 minutes. I'm just going to get to his remarks. I didn't find his remarks in the public hearing, but he chaired this meeting. So let me get this here, get the speed up, 1.5. There we go.
I'm going to support the original motion. I do think the bill has some need for improvement. We need to take it out of the FGM, and maybe there are some statements in there that aren't exactly accurate. I do I also look at that do no harm, and I think that cuts both ways. We're talking about.
It's really difficult there, but I am going to support the original motion. Thank you.
Thanks, Senator. Okay, I'll make a couple comments as well. I'm going to support the original motion. I do think the bill has some need for improvement. We need to take it out of the FGM, and maybe there are some statements in there that aren't exactly accurate. I also look at that do no harm, and I think that cuts both ways. We're talking about children under the age of 18, and I don't think they are old enough to make these kind of permanent decisions. We've got doctors on both sides giving us good, credible opinion, as it is a really difficult issue. It's very emotional. We heard that from both sides today. Parental rights are important in Idaho. We try to protect those, but we also have child protection laws that apply to that. So we're always trying to find the right balance of respecting both of those things. And I want to make sure that we're not doing permanent harm to our children. But I'll support the original motion to send it to the amending order. Any other thoughts or comments? Okay, Senators, we have the motion before us. The substitute.
Okay, I mean, you can watch that video if you want. There was quite a bit of testimony in that. And then I think I'm going to wrap this up with this one here. This was some kind of gun bill. And actually, I didn't really look into this. I just saw that this had come up in some discussions. And what's interesting is there was some debate. This is about maybe brandishing or saying that you have a firearm. But yeah, I mean, this is kind of like the bonus part if you stuck through all of this. We're getting close to an hour. This will be the last one. So, yeah, I mean, Senator Lakey is the tip of the spear in regards of this, regarding the anti-abortion items, and I think he should get consideration about that. And obviously, he's very articulate. I mean, he's a practicing attorney. He knows what he's doing. He's a committeeman, a chairman of a committee. I mean, there's a lot of things, and I think those should all be considered. And you see how in depth I went through on him. His social media presence is really bad. Like, he doesn't post these kinds of things. Like, I'm probably his #1 fan now in terms of publishing, obsessing, right? I'm about to post an hour, right? This is an hour of me just obsessing over all of these videos, and, you know, even me, I guess, trying to find all of these videos. What did I spend, like, maybe, 4 to 8 hours? You know, and all of these videos are the sessions are like 6 gigabytes. You know, that 7-hour session, you know, there's 6 gigabytes, and I'm downloading all of these, and I'm hopping through and, you know, watching all of his comments. But I mean, I think nobody goes to this level of in-depth looking at you know, Senator Lakey here. And, you know, even that would be my criticism of, you know, Stop Idaho Rhinos or the IFF, and of course all of them, all you know, in terms of the ones that focus on the material side of things, and aren't looking at the moral aspects of, as they say, politics is downstream from culture. So we need to maintain the moral backbone of Idaho and encourage those who share those moral Christian values, and discourage those who do not share and find those laws to be hostile, and have them find, you know, a state, have them move somewhere. And that's, you know, that's also part of, you know, where you have so many refugees, political refugees coming from California, is because there's such moral depravity. And so these laws that are so polarizing and so offensive, you know, regarding this transgender stuff, the transgender things, the abortion, let it be offensive. let these laws be offensive, and they say it's offensive to some, and then it smells sweet to others. And as you have the Great Divide happening across the nation, this is all part of that process. And so when you start talking about taxes, and it's like, would you? And anyway, that's a whole nother discussion. Let's just finish this up. All right, it's enough. All right. Okay, I'm sorry. I thought I had this queued up here. 4:44. This one was 6 hours and a half.
And it is in this order of business.
Thank you, Mr. President. I move that all rules interfering with the immediate consideration of Senate Bill 1173 as amended be suspended.
Mr. President, I second the motion.
Heard the motion. This is a non-debatable motion. Requires 2/3 of the body or 24 votes for passage.
Mr. President, all rules
to
prevent
The general so it's
offenses.
Mr. President.
Senator Lakey.
Mr. President, I ask unanimous consent that further reading of Senate Bill 1173 as amended be dispensed with. The general so it's read the third time at length and properly placed before the Senate for final consideration.
You've heard the request. Is there an objection? Hearing none, it is so ordered. Senator Lakey, you are recognized to open the debate.
Thank you, Mr. President. Senators, I think you all know that in Idaho we have some really good stand your ground and castle doctrine Second Amendment legislation and protections. That's primarily found in 19202A, which provides that we can use all force or means necessary to protect against certain serious or heinous crimes. We also have Idaho Code Section 19202, which regards resistance to or in response to threatened use of force by a threatened party. And this bill amends that section. That section provides an individual the opportunity to provide resistance sufficient to prevent an offense. There's a little bit of room to argue in that language. I think I can argue that the conduct that's described in this bill is covered by that and arguably covered by 19202A, but I think you can also argue that it's not. This bill amends 19202 to provide clarity to that situation that actually stops short of a use of force when you're defending yourself or defending others. This deals with what's called or referred to in the bill as defensive display or declaration of a possession of a firearm. So in other words, if you're faced with that type of situation, this covers that opportunity where you simply want to advise somebody when you're faced with that threatened use of force that you have a firearm to help defuse the situation, or to display the firearm that's under your jacket, put your hand on it while the firearm is still within its holster. It does not cover actual drawing of the firearm or use of the firearm. Senators, assault is a crime in Idaho. That's a threat of force against a person, and that can either be by word or action, and that's a misdemeanor. If you use a firearm in that threat of force, that's a felony. That's an aggravated assault. This bill, again, provides protection against that in this particular situation. It provides that a person, when faced with unlawful force, which means it doesn't cover law enforcement lawfully uses force in the exercise of their duties, or if somebody is lawfully using force against you, it's not covered here. If you're faced with that unlawful use of force, as I said, you may state that you have a firearm or display that firearm in a holster. It also provides that you're not protected if you're provoking the person to generate a response. So you have to be in the right in this case. It requires that the response be necessary, and it utilizes the reasonable person standard that we're familiar with that's already contained in this code and also contained in our stand your ground doctrine. That's a reasonable person judging from what they knew at the time and what they're seeing at the time without the benefit of going back and looking in hindsight. That's the standard. It still applies. So, Senators, this gives you an opportunity to respond with something less than actual use of force in defense of yourself or others. As I said, it specifically notes that this is an option. We made it clear in the bill as well that this does not require some kind of graduated use of force where you have to do this before you can use some other type of lawful force. So this is simply an option, not a requirement. This language in this bill was developed in cooperation with the NRA. It has their support. Also, as always, when I work on these bills, I coordinate with law enforcement. Law enforcement is neutral, the various agencies. So, Senators, I'd ask for your support for this clarification on something less than an actual use of a weapon. Debate is open.
Okay, so I actually didn't pre-watch this. This came up at the very end of my research, so I'm just going to peruse it live with you.
President.
Senator Wintrow.
Thank you, Mr. President. To debate against the bill and
Okay, I'm going to skip Wintrow.
also stretch my legs.
To display it without your hand on it, without pulling it out of your holster, without any
against this bill.
Thank
Is there further
you.
debate?
Mr. President, thank you. Just to clear up one thing real quickly, I don't believe this bill allows anyone to brandish a weapon. What it does is allows you to display it without your hand on it, without pulling it out of your holster, without pulling it out of your pocket or your back pants pocket. So I don't think it's about brandishing. I think it's purely an effort to try and de-escalate a situation and let someone other than a law enforcement officer know that they're threatening you.
Is there further debate?
Mr. President.
Senator Schroeder.
Thank you, Mr. President, to debate and to, I guess, help add to the clarification. As a prosecutor, I've encountered this statute a couple of times, Idaho Code 183303. Since it's a statute, I don't think I need to ask permission to read from it. Exhibition or use of a deadly weapon. This is the one that proscribes or doesn't allow you to, when not in necessary self-defense. Every person who, not in necessary self-defense, in the presence of two or more persons, draws or exhibits any deadly weapon in a rude, angry, and threatening manner, or who unlawfully uses the same in any fight or quarrel is guilty of a misdemeanor. So the conduct that we're worried about is already proscribed and is a statute that I have enforced and prosecuted successfully when it was improper. And so I think that this bill is well motivated, and I'll be supporting it. Thank you.
Further debate?
Thank you, Mr. President, to debate the bill.
You have the floor.
Thank you, Mr. President and fellow senators, to debate against the bill. I do have concerns with the bill, and I'm now have another concern because the definition or the reading of the statute, the criminal statute under Title 18, seems to create some confusion with the definition of defensive display under this bill. So subparagraph 2 says the defensive display or declaration of a firearm by a person is justified when, goes on to tell us when. And then at the bottom of that paragraph, it gives us the definition of defensive display or declaration of a firearm. And it includes verbally informing somebody that you have a weapon. And exposing, it also includes this, exposing, displaying, or placing a person's hand on a firearm. So tapping where the firearm is, showing that you have a firearm. It does have to be contained in a holster, pocket, purse, or other means of containment. But it seems to contradict the statute that we were just read from Title 18, at least in some part. I guess, when I think about these statutes, or these sorts of statutes, especially this one, where we're talking about brandishing, letting other people know, hey, I'm armed. I always think about what's the worst situation where that could take place. And for me, it would be, in one of these rallies where tempers are hot. And we've seen some of these clearly. So I think,
Mr. President, to debate the bill.
Senator Trickley, you have the floor to debate the bill.
Thank you. As somebody with very extensive weapons training in actually utilizing weapons in a particular situation, I have some concerns with this bill. To me, the training I receive, obviously, you read the room, you read the individual, intent, emotions, all that has to be taken into play. But unlike many citizens, I've got training to recognize that and be aware of that. And to me, the second somebody were to go, I'm going for mine as well, because it's a split-second decision to pull it out and shoot. And I don't know if they're reaching for a weapon to pull it out and shoot me, or just to scare me. So I've got concerns with it, but I am going to say I am going to vote for this bill for the simple fact that I don't think it is anybody's place to tell another individual when they feel threatened how to protect themselves. I'm hoping that when people look at this, they will realize that the only reason you ever need to touch your firearm is if you feel threatened and you intend to use it. So I would urge you to remember that in a situation of life and death, when you feel extreme peril or damage to yourself or others, do we have the right to tell them what they felt in that moment was right to defend themselves or not? So I would ask you to consider that in your vote, and I will be voting in favor of this bill. Thank you.
Mr. President, to debate the bill.
Senator Hurd, you have the floor.
I'm a little conflicted about this bill because I don't necessarily understand it, and I have an attorney representing me right now in a Supreme Court case, and his name is Don Kilmer, and he's with the Second Amendment Foundation, and he sent me information on this today. And do I have permission to read from an email from Don Kilmer of the Second Amendment Foundation regarding Senate Bill 1173?
Having cited the source, yes, you do.
In Mr. Kilmer's opinion, he says that the flaw is there's a multiplicity of legal authorities addressing the subject the bill addresses. In particular, he cites the current jury instructions that I found on the Supreme Court's website. And he says it is settled law that brandishing is a valid affirmative defense when your life, the life of your family member, or a third party is being threatened. In that case, you are absolutely privileged to do what every cop does, escalate force from warning to brandishing to actual use of deadly force. He says it is also settled law that brandishing can be an affirmative defense when confronting someone, trespassing land or chattels, but, and this is critical, you can't actually use deadly force to defend mere property, whether land or personal property. If SB 1173 and the jury instructions need to be amended to make this clear, then that is where the effort belongs. There are already at least 2 reported Idaho appellate cases interpreting these jury instructions. Before voting on SB 1173, those cases need to be read and understood by the legislature to see if they reflect what the policy should be. In other words, if those cases accurately reflect the will of the people of Idaho through the current state of the law, why confuse things? If these cases do not reflect that will, then we should change both the statutory law and the jury instructions. And with that, I just stand confused about what we're accomplishing here if my own attorney believes this is going to create confusion. And so if we're voting on this today, then I'm going to vote nay. But it's not because I don't respect the Second Amendment and the right to defend oneself. It's because my own expert attorney, who's with the Second Amendment Foundation, believes this will create confusion and not lend clarity to our purpose in this bill.
Mr. President, to debate the bill.
Senator Foreman, you have the floor.
Thank you, Mr. President. I appreciate the sponsor bringing this bill, and I know from past experience that when this sponsor brings a bill of this nature, it's intended to help and to clarify and to support people's Second Amendment rights. However, I have concerns.
So a little bit, Senator Foreman is the co-chair with Senator Lakey with the Judiciary and House Committee. So they know each other probably pretty well. They sit next to each other for all those hearings.
Concerns with this bill. I just think there's too much minutia, if you will, in the bill. It talks about displaying a weapon or making it known that you have a weapon. I've heard the term brandishing used a few times here on the floor. And as a retired police officer, I can tell you what my training dictated to me. You don't brandish a lethal weapon, ever. You pull a lethal weapon out of its holster because you think you may need to use it. It's not meant to send a signal to anyone that they better back off or change their ways, because if they don't, there could be consequences. That's a very, very, very dangerous path to go down. And quite often, it prompts a response from the other party that you don't want. A lethal weapon stays in its holster until a situation presents itself where you reasonably and honestly believe you're going to need to take a human life in defense of your own or somebody else's. Any talk of brandishing in the department I work for would get your hand slapped really quick. Now, you take a scenario where you don't have a trained police officer. You have a civilian who may be 1 or 2 drinks into being on his way to being not a clear thinker, or somebody who's scared, or somebody who has 0 firearms training, and now he or she may think it's a logical next step to show a weapon. It is not. It is not. And that's my opinion based on a lot of years of being a police officer and also being in the military. So again, I really want to vote for the bill because I like to do whatever I can to strengthen the Second Amendment, but I think this would introduce a little bit of confusion and may even induce somebody to go to that next step, which, as I said, you don't really want to go to. So I'll be voting no.
Further debate? Hearing none. Senator Lakey, you're recognized to close the debate.
Thank you, Mr. President. Senators, appreciate all the debate. I'm not going to go through the numbers. There were a few too many. But, Senators, this is something that we have been looking at with the NRA for a couple of years now, and looking at examples from other states, Montana, I believe North Dakota, Arizona, and other states that have similar statutes that talk about defensive display or declaration. Senators, a self-defense situation is always factual. What this provides is the opportunity to not draw your weapon, to stop short of that, to not shoot someone, and have that conduct that's deemed in your best reasonable judgment to be protected. As I said, there's room to argue in the existing statutes, whether 19202 covers it or 202A covers it. They clearly cover drawing your weapon, but stopping short, you should have that right, that ability to do that, and this provides that clarity. As the good senator, I believe, from 20 mentioned, it does not cover brandishing. Brandishing, drawing of the actual weapon, short of firing it, waving it around, however you want to describe that act, that would have to be covered on 19202 or 202A. That's not the scenario that we're talking about here. Also, senators, it does not cover property. It only covers the defense of you or another. So, senators, again, this is not a required action. It just gives someone the ability to exercise their Second Amendment right to diffuse a situation where they're faced with a threat of violence short of actually taking violent action. With that, debate is closed.
Debate being closed, the question before the Senate is, shall Senate Bill 1173 as amended pass the Senate? The Secretary will call the roll.
Adams, Anton, Berndt, Bierke, Burnshaw, Carlson, Cook, Van Hartog, Foreman, Rowe, Guthrie, Harris, Hart, Harkin.
The roll call shows 18 in favor with 17 against. The majority having voted in the affirmative, Senate Bill 1173 as amended has passed the Senate. Hearing no correction to the title is approved, and the bill will be transmitted to the House.
Okay, I thought that one was interesting. So, what's interesting is you have the NRA, which supported the bill, and then the Second Amendment Foundation of, I believe, of Idaho, I guess, opposing the bill. So, what it's just, there's just some crazy things some weird things. I guess they don't get along. Okay, so I think that's pretty much it for the review. Ultimately, I don't know if any, Senator Lakey is up for re-election on this May. And, for the primaries. So we'll see who ends up running against him. But he's very interesting. I mean that. I don't. There's just it's a lot more complicated. I guess I'm more undecided. I mean, you see what he's bringing forth, and Second Amendment, the transgender issues, the abortion things, regarding the abortion laws. He for all the moral aspects, he's good to go. And then even on the launch program, he voted no. The issue might be with the spending. I would have to look through. It seems like on the big ticket items, he's good. The score wise regarding IFF and what does that mean? He's borderline philosophically Republican. That would require me to look further into the methodology. But generally speaking, I mean, his reasoning is sound. Like I can understand his position on things, and just the blanket claim that he's, a lackey. Unfortunately, his name is very similar to lackey. That as though he's a lackey to Ayaki is not. I don't think is substantiated based off of what I've seen. Not 100%. It might coincide. What could be interesting, that 7-hour hearing when he was talking about the abortion bill, that was when they voted on the H369 bill, so he probably didn't want to overstep the debate. I guess that would be kind of my question would be, that there is I think that the discussion regarding taxes and spending is more of a, and then corporate cronyism. That's a video that I posted, I think, previously. When you have just corporate income taxes alone bringing in $1 billion, it seems to me that those companies would be entitled. It's their money to determine how it's being spent, and because the companies cannot vote and have that sort of influence, they influence through money with the politicians, and obviously they spend their monies, as I spoke before, quite a bit on Senator Lakey. But remember, these companies, the money that they invest goes back to Idaho. It creates jobs in Idaho, and then so those taxes come back to Idaho, comes back into the coffers. So it is like a closed loop system. These aren't like pharma, I guess, I don't know, pharma companies or car manufacturers who are building factories out in Mexico. These tax dollars are coming back to Idaho. So this is a much more nuanced discussion. I don't think the points necessarily discuss the moral angle, which I believe is more important. And because the moral aspect, basically, you either encourage or discourage those people who share those values. And when I say morals, I specifically refer to Christian values. And as the founding fathers, the U.S. expressed, the system, the governmental system of Idaho will not function unless you have a moral people. And so, when you start when we start for the laws, basically offending those with different moral values or systems, that is actually what you want. That is a better thing, and that helps with the attracting the kind of electorate that you want, the kind of people, that your tribe that you want to be around. And the thing with economics is, or with taxes and low taxes, is because low taxes will attract those with poor morals, with a moral system that you do not want, with moral systems that you do not want anywhere near your children in your public schools, corrupting, degeneracy, just. So that, I think, that would be my biggest criticism against the pure economic, kind of libertarian sorts of views, is you can go super small taxes and very small expenditures, but who does that really? Well, I don't know. That's a bigger discussion, and I'm arguing with myself on air. All right, have a good one. Bye-bye.